Recently, I've received lots of questions about qualified immunity and the potential impact of HB 1280, also known as the George Floyd Justice and Policing Act of 2021, which passed the House of Representatives but has an uncertain fate in the Senate. There are lots and lots of major proposed changes to policing in the act, including redefining what constitutes deadly force and uses of force in general, but I'm focusing on the critical language related to the author's attempt to change qualified immunity. The new language says the following: in taking police action, it shall not be a defense that the officer was acting in good faith, or that the officer believed, reasonably or otherwise, that the officer's conduct was lawful at the time when the conduct was committed, or that the law was not clearly established at the time of the police action, or that the state of the law was in a condition that the officer could not reasonably have been expected to know whether the officer's conduct was lawful. According to the George Floyd bill, an officer could face legal, personal liability for simply enforcing a law that the officer is obligated to enforce, even if the law has not been struck down by a court, and even if the officer had no way of knowing that the law or police practice would later be deemed unconstitutional. This is crazy, and I have strong doubts as to whether the U.S. Supreme Court would let this language pass constitutional muster. But even if this were to somehow pass Congress and be signed by the president, ASCOPS has a plan to protect its members in the event that qualified immunity was actually modified by Congress. Our legal plan is the best in the state, and we have a contingency plan to provide additional protections if the George Floyd bill were to pass. With all of that context, please watch this week's video to understand the history behind qualified immunity and why it makes sense for policing in uncertain situations. Today's topic is qualified immunity for police officers. So I'll briefly cover what immunities in the law are, the level of immunity that officers have, and how it makes sense based upon the job that the police do in the United States. I'm Steve Serbalik, and I'm a panel attorney with ASCOPS in Arizona. Remember, this is a topic summary and not legal advice. First, in order to understand qualified immunity, it's important to understand how qualified immunity is different than absolute immunity. Absolute immunity exists for certain individuals performing key functions in our justice system. For example, generally speaking, judges receive absolute immunity for the decisions that they make in their role of issuing judicial decisions, and prosecutors receive absolute immunity for their decisions as to whether or not they bring criminal charges forward. Absolute immunity is what it sounds like. Judges and prosecutors can never be held civilly liable for their absolutely immune functions. The theory behind this immunity is that society would not function well if judges and prosecutors could face financial penalties for their decisions, and that they should not be faced with defending civil lawsuits for those decisions if they happen to be decided incorrectly. Police officers don't have absolute immunity. They have a lesser form of immunity called qualified immunity. Qualified immunity exists to protect officers from facing civil lawsuits in cases where the law is not clear. It started with a case in Mississippi where officers made arrests under a state law involving breach of the peace and refusing to, quote, move along when directed to do so by police officers. Courts later found this particular breach of the peace law to be unconstitutional, but when the officers made the arrests, they had no way of knowing that a court would later strike down that statute. After the law was determined to be unconstitutional, the officers were sued for making the arrest. The Supreme Court recognized that this was an unfair result and held that, quote, Mississippi law does not require police officers to predict at their peril which state laws are constitutional and which are not, end quote. In other words, if police officers are acting under the good faith belief that their actions are constitutional because no court has held otherwise, they are protected from a civil judgment by qualified immunity. Or, to quote the Supreme Court in Ashcroft versus Al-Kid, qualified immunity protects officials who make reasonable but mistaken judgments about open legal questions. This is also important because officers are expected to follow agency policies, even if these policies are later struck down by a court. For example, officers are expected to follow their training regarding taser deployment, But if a court later determines that tasers cannot be used in certain circumstances, it's fundamentally unfair to penalize the officer in the department for failing to predict what a court would later find to be impermissible. Now, contrary to some news articles, there is some conduct that is so outrageous that even if there isn't another case directly on point, officers can still be sued for violating constitutional rights. For example, in Hope versus Pelzer, the Supreme Court held that correction officers who punished a prisoner by tying him to a hitching post, immobilizing the prisoner for a long period of time, and subjecting the prisoner to sunburn, dehydration, and muscle aches was unconstitutional on its face, even though there wasn't an exact case on point discussing hitching posts and prison guards. In other words, there is no qualified immunity for outrageous conduct that obviously violates someone's constitutional rights. It's not absolute immunity. Qualified immunity only protects officers when the law is not clearly established, since officers shouldn't be forced to guess as to what laws or applications of laws courts would find to be unconstitutional in the future. So to recap, qualified immunity is not absolute immunity. It is limited, and it protects officers who make reasonable decisions that have not been determined to be unconstitutional. Qualified immunity does not protect officers from extreme misconduct, and if courts have ruled something to be unconstitutional, from that point forward, qualified immunity for that conduct no longer applies, and officers and departments can be held civilly liable. If you have questions or comments about qualified immunity, leave them down below. And if you found this video helpful, please hit the like button and subscribe for more law enforcement lessons. Videos come out every Sunday at 5:30 p.m. Arizona time. Thanks for watching. I'm Steve Serbalik. Stay safe out there.